popular government without popular information or the means of acquiring it is but a prologue to a farce, or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power which knowledge gives. A very good evening to you, ladies and gentlemen. Law Essentials welcomes you to the third episode of the Lawyers as Peacemakers series. We will be talking today about LGBTQ issues. Law Essentials has successfully completed its 6 months in this October. It is a student-run initiative by a group of inquisitive law students having a penumbral idea about the application of law in day-to-day life. We provide knowledge through continuous research, training, and development to improve learning by offering various certificate courses with highly qualitative professionals. In India, the Lok Sabha recently passed the Transgender Persons Protection of Rights Bill 2019. The new bill is the first formal protective measure they have in a progressive legal system and is long awaited. The apex court of the country has reiterated landmark judgments in the cases Nalsa versus Union of India, Justice K.S. Puttaswamy versus the Union of India, and Navteej Singh Johar versus Union of India. According to me, there is no human right to do a human wrong. Let me introduce you the speakers for today's session. We have with us Maureen Truax Holland Associates. She is from Holland Associates and she is PC Holistic Attorneys and Counsellors at Law in USA. We also have with us Mr. Najeed Naved Siddiqui. He is pursuing his Masters from National Law University, Odisha, India. We also have with us Angie Martell. She is from Martell Law Firm, USA. Thank you so much to all the speakers for joining us today. It's been a pleasure to host this event. I would request Maureen to start off with her part.
Thank you so much. Thank you, Farhan, for inviting me. And I know Kim Wright is somewhere in the background. And thank you, Kim. And I look forward to our discussion today. Also, a welcome to all of the participants and wherever you are and whatever time zone you're in. I'm just delighted to speak today. I am a holistic lawyer located in Memphis, Tennessee, who practices civil rights and employment law. And I'm going to be talking about LGBTQ issues as it relates to a marriage equality case that I participated in, and as it relates to employment discrimination issues that I fight against and our law firm fights against every day. So here's just a short background on me. We are in Memphis, Tennessee. We have a small law firm. It's very usual to have small law firms in the United States. I work with my younger daughter, who is an attorney. So we are a mother-daughter law firm. I think we are the second mother-daughter law firm in the city in which we live. We primarily work on a number of issues related to employment. So if you are an employee of any employer, including the government or city, county, federal government, or for a private company, and you run into an employment problem, then the person you look for in law here in the US is an employment lawyer who focuses on employment issues. And that's what we do, representing employees, not the companies, not the employer, but the employees. And in 2014, when I was working, just as most lawyers do, we just get up in the morning and work, go to bed at night, and as we're still half working, I was speaking to a friend of mine in Nashville, Abby Rubenfeld, who is an attorney, and I really wanted to participate in helping to change the law for the better for LGBTQ individuals who were interested in getting married and who wanted their marriages protected. At the time, I was married to my wife in a state in Tennessee here where our marriage was not recognized. That is, we didn't have the same protections and we didn't have the same rights as individuals who were married, and they were opposite sex. So one was male and one was female. So same-sex couples did not have the same rights in 2014. And 2014 and 2013 was a pivotal point, because I say 2013 was a pivotal point of realization we need to do this, because the federal government here had, through the Supreme Court, made a ruling that the federal government had to recognize same-sex couples and provide rights to same-sex couples who are married. That had not happened before. In fact, there was a specific law called DOMA, the Defense of Marriage Act, that was enacted in 1996 that said you can't do that. Marriage is only between a man and a woman. So there was this many years of fighting about that legally. And in 2013, in a case called Windsor versus United States, the law changed. When the law changed, I wanted to help change it as to individual states, because just because the federal government, the overall government, says your marriage is recognized, that was not so in individual states. And individual states could still discriminate and provide different protections or no protections. So we began this case and filed the lawsuit. I said 2014, it was 2013. We filed the lawsuit, and we fast-tracked it. We didn't know. We were a very small case in Tennessee, and we knew that a way to work through the legal system rapidly was to file for an injunction. That is an order from a court that directs immediate action. And immediate action orders, like injunctions, are also immediately appealable, whether you win or lose. So we filed an injunction because one of our couples in Tennessee was pregnant. They were pregnant and they were about to have a baby. And we needed the baby to have parents that were both recognized and not just one parent recognized. And so we petitioned the court and asked the court to enter an order saying the marriages of our couples that brought the lawsuit, the primarily three main couples that pursued the case, that their marriages needed to be recognized, including the couple that were about to have a baby. And the judge agreed. The judge in Tennessee said, "You're right. We must do this for the protection of the child, so that if something happens to one parent, the other parent has equal rights." And that order was entered, and that order was immediately appealed by the state of Tennessee to the next level. And we in Tennessee are in the Sixth Circuit. So in the United States, the Supreme Court is at the top, and then below that are courts of appeals that are all numbered. And the numbered circuits are a collection of states. We're in the Sixth Circuit, so it was a collection of states from Michigan, Kentucky, Ohio, and Tennessee. Tennessee appealed, and when we got to the Sixth Circuit, there were other cases already there. There were cases from Michigan, cases from Ohio, case from Kentucky. So there was a case that the Sixth Circuit was going to now collectively look at these issues related to marriage equality, marriage recognition, and the right to marry. Those cases the Sixth Circuit put together for purposes of an argument. And the courts can put cases together if it wants to. And it did. It put them together mostly based on who showed up first for the appeal, who filed first. And so at the Sixth Circuit, it had one name, a particular set of the first name. Like if you go to a restaurant and you're the first of your friends to show up, and the restaurant says, whose name do we put down? And you say, well, mine, because you were first, and you tell all your friends it's under my name. That's the same thing in the court system. Whoever shows up first gets their name on the case, but that doesn't mean they're the only one involved. That's just what the court calls it. So at the Sixth Circuit had these cases, collection of cases, where each of the trial courts had ruled in favor of the individuals. And the Sixth Circuit ruled against everybody, said no recognition, you don't have a right to get married in a state that doesn't want you to get married there. And a state does not have to recognize the marriages of other, if you got married in a state that did allow you to get married and you move because you're required to because of the type of work you do for the federal government, or move because you needed to for a job. Doesn't matter. If the state you move to doesn't want to recognize your marriage, you're no longer married. And that decision created a split. That is to say, some circuits had said, of course you should be married. But the Sixth Circuit, in saying no, absolutely no, that created a divide among the circuits. And the Supreme Court of the United States tends to only take cases where there is a difference of opinion among the circuits. And it's called a split. And when there's a split, they will decide if they're going to take a case. They don't take very many cases. They take a very small percentage of the cases that are filed. We filed an appeal and the court made everyone file. So these cases that had been put together now are separated again, and everyone filed. When we got to the Supreme Court, we were the second of this collection of cases to file. And so we were put together with whoever showed up first, like at the restaurant. And that was the Obergefell team. Their case filed a few hours ahead of our team. But all of the cases were put back together by the U.S. Supreme Court. They were consolidated for purposes of this decision. And although there's been a lot of press, and I think there's certainly a thought that there were only two individuals or one individual that formed the Obergefell case, that is incorrect. There were 16 couples that formed the Obergefell case. There were children involved. There was a funeral director involved in the case, and there was an individual whose spouse had passed away. So it wasn't just, it's one person or two people that formed this case. There are many plaintiffs who were fighting, some who had gone through full trials, who had made their way to the U.S. Supreme Court. And in 2015, on June the 26th in 2015, the U.S. Supreme Court ruled in favor of all of these individuals and in favor of all same-sex couples, that all same-sex couples, number one, had the right to get married. That is to say, a state couldn't deny them a marriage license. Specifically said, you must give out marriage licenses. And that if you were married in one state and you had moved to a state that was refusing to recognize your marriage, well, now that state had to recognize your marriage. All marriages that had been created in states that allowed it were now to be recognized. And this was a landmark decision. This was huge because the Supreme Court, for the first time, recognized that a marriage could be between two same-sex individuals, not just between a man and a woman. And this was a huge change of decision-making. And this created then the next question, which was, great, now we're able to be married. And I was part of this case. It was the Tennessee team had to be involved all the time. We're a very small collection of attorneys and plaintiffs. The next question was, now that you have had the right to be married, if you go and tell your boss at your company, I got married yesterday to my wife, does the company have the right to fire you? Can you be treated differently in your job? Is that some benefit of being married, that you can't be treated differently because of your marriage? Or is that protection provided by some other laws? And this issue after 2015 was challenged in the court system because individuals were being discriminated against who told their employer, I'm gay, I'm lesbian, I'm transgender. The employers were like, you're fired. Goodbye. And these cases were fought and brought to the U.S. Supreme Court. And this year, in 2020, the U.S. Supreme Court ruled that a law that was put into existence in 1964, civil rights law, protects all individuals who are terminated or treated differently because of their sexual orientation or gender identity, transgender status. I think my time may be up. But that brings us to today, where we're at in terms of that's a very fast story, but it just goes to show that even though you're working every day, you can get involved in something that turns out to be bigger than you realized, and it can make a change for the better for individuals that impacts a very large group of individuals for the better.
Moving further, I would like to request Mr. Najeed to take over.
Thank you so much, Farhan. Thank you, Maureen, for such a brief, historical timeline for the cases that happened in the US. When I said that we have an approach here in India to look towards the West, I specifically, in my dissertation, in my master's dissertation, I specifically had this portion where in my dissertation I talked about cases from the West, like as you quoted, the Winster case, the Obergefell case, the one incorporated case, and different cases, Lawrence versus Texas case, because these specific cases have been quoted by our judges. So that gave me a sense of inquiry, or it struck me that as to why we were looking to other jurisdictions, or why were we not having an indigenous approach towards this particular issue here in India. Because very recently, in the past, I would say the past month, there was a petition filed in the apex court in India, that is the Supreme Court of India. There was a petition filed that same-sex marriage should be allowed. So that particular petition came before the Supreme Court, and the Solicitor General of India, he replied with statements like that same-sex marriage is not permissible in India, or he stated that our virtues and our traditions don't allow same-sex marriage in India. So there is this word moral fabric that has been used quite a lot in India, and for every question regarding this particular community, or when we talk about equality for this community, when we talk about anti-discrimination issues for this community, this particular word of moral fabric has been thrown out as the answer for everything. That we have this moral fabric that binds the society, and all that crap we have, that it is that thread that binds the society, or if we do something other than what has been done for a very long time, this particular fabric would break, and then the essence of the society would in turn diminish. That is the statement that generally the majority use. So what happened in 2018 here in India, we had this judgment called Naved Singh Johar, as mentioned by Farhan, Naved Singh Johar case, where the judges, there were 5 judges in that particular case, and there was one judge, Justice Rohinton Nariman. He said that there has to be wide publicization or the sensitization of the majority. There has to be, this particular judgment has to be published in books, published, like it has to be talked about really, it has to be talked about on television, on radios. We have to actually have discussions regarding this particular topic. So I thought, what actually was the reason for a justice of the Supreme Court saying that we have to talk about this? Because being a law student, I would presume that a decision has been given. So since a decision has been given, that is it. We know that things will go forward from this point of time. But that's not the case. Here in India, when I particularly, this particular subject, I developed an interest regarding this particular subject when this particular judgment of 2018 came. So while having a read regarding this full history of the LGBTQ movement in India, that is from the, I would say there was an act here that the Britishers gave us. That was the Criminal Tribes Act. That was from, I guess, 1871. There was an amendment in that particular act in 1897 that allowed the authorities to actually arrest people on the presumption that they were, because of their birth, they were open to crimes, even if they don't commit that crimes, because of their birth, they were criminal in nature. So there was this generalization or this discrimination against the transgender communities here in India. And to me personally, that was the biggest instance of legal discrimination against the community. The next century, as we have seen, there was little to no development here in India, talking about India specifically. In 1981, and I would say 1991, 1996, there were certain instances where petitions were filed, but the court said that there was no locus standi. There's no issue to discuss, because there's a word here in India that we call popular morality. The word popular morality has been thrown out uh, in such large numbers that this particular thing we say that this is the justification for everything that is against our so-called traditions, against our so-called culture. I don't know where it is written, but since our customs, our traditions, our moral fabric, as I've already stated, if anything goes against that particular general norm, gender norm that has been here in place for a very long time, so if anything goes against that particular norm, we say that it is against our moral fabric or popular morality. Something that has been questioned in this 2018 judgment, when we pinned it against the constitutional morality of a constitution that has been in the constitution since 1950. So the constitutional morality aspect of the constitution was put head to head with this popular morality, this thing. So what happened in India, the issue for the community has been answered. I would say it has been answered judicially. The people were not involved. The community was not involved. The majority in general was very well. They were unaware of this particular development that was happening since 1991. Since a petition was filed in 1991 and it was decided in 2010. So it took 19 years to actually decide that a particular section of our Indian Penal Code was very discriminatory, because it punished same-sex activities, and that too consensual activities. It punished it, and it was a criminal act here in India. And what shocked me when I was actually studying this timeline, what shocked me was within 5 days there were 9 petitions against that particular judgment in 2010 by various eminent personalities. And the obviously in 2013 that particular judgment was repealed, overturned in Suresh Kumar Kaushal case in 2013. When you were talking about 2013, where you were trying to step up your game and trying to fight for your rights, we were actually going back to from where we started. So it's really like when I say to me personally, when we say that we have an approach that we look towards the West for legitimacy, so that, can you just pause for a minute? Can I just pause for a minute?
I appreciate what Najeed was saying about criminalizing same-sex couples' intimate behavior in the United States. He mentioned Lawrence v. Texas. In 2003, the United States, by a Supreme Court decision, said that states can no longer criminalize that behavior. Of an interesting note, that particular decision was decided on June the 26th in 2003. The Obergefell case was decided on June the 26th in 2015. The Windsor case was decided on June the 26th in 2013. But I appreciate Najeed's comment.
Okay. So the thing that I was saying, that since here in India, and as I was saying that in 2013, we took a step backwards. We took a step backwards here in India regarding the community, because in that particular judgment, when we read the judgment, there were 2 things that were expressly mentioned. First of all, the community was called minuscule minority. So the rationale that was given was that since they are so less in number, it's okay. And second, that our traditions and our customs. So the judgment was purely based on popular morality. So it wasn't, and the judges said that we are not tackling the issue of that particular section of the Indian Penal Code, but we are discussing about the popular morality, and the popular morality states that we cannot allow such things. In 2014 and in 17, there were two cases, the privacy case that was discussed in India, and the other case that was Nalsa, as mentioned by Farhan. In these two particular cases, we talked about concepts of autonomy of the body, we talked about the concepts of privacy, and it was here that we essentially developed this idea that privacy was a part of our Article 21, that is a right to life. So to live with dignity, to have a private life doesn't mean that you actually, whatever you do in your private life, that actually is privacy. But privacy actually means that a person who is not involved in your actions, he doesn't have a say in your actions. So if you're not actually affecting anyone, and I'm not saying about that moral fabric and everything, but if you're not actually affecting anyone, that person doesn't have a say. That is an aspect of privacy that was discussed. So coming back to this 2018 judgment, where this particular section was decriminalized to the extent of punishing the same-sex activities. So that is 2018. A simultaneous debate or a simultaneous development was happening with regard to the legislation. That bill that Farhan mentioned, that was a bill that that was presented before the parliament in 2014, that talked about the laws we could actually make for the welfare and development of the community. So as Farhan said, that the particular act has been passed in on, I guess, on 5th December 2019. So one would expect that that particular act would have certain laws that would actually help the community, but that isn't the case. So in 2014 to 2019, there was various developments, but the government actually, in some cases, it actually, I would say, it neglected the opinions of the standing committee of the parliament, and they did what they wanted to do. And the particular act of 2019 was passed on the very day when we had this judgment of uh, abrogation of Article 370 here in India, that was celebrated. But on the same day, this particular bill was became an act, and it wasn't discussed. That particular act and that particular bill wasn't discussed. The community wasn't involved, and it became an act. And it came into force on 10th January 2020. So it's a very recent development for the community here in India. So we don't actually have a, I wouldn't say, history of this protection and attitude of protection towards the community here in India. So we're actually trying to do this. But after reading the 2018 judgment, what I personally believe that the judges tried to actually take a harmonious construction. They made a harmonious construction because they actually know the present condition of India. Here in India, the popular morality and the traditions, they speak otherwise. So we are heading towards human rights. We are heading towards development. We are heading towards protection for the community. We are making laws for the community. But when we actually scrutinize, when I personally, for my dissertation, scrutinize the particular act, scrutinize the judgments, there were concepts that the judges use, like innateness of gender. To me personally, gender is fluid. Gender is just like a liquid. You can pour it to any vessel. It doesn't matter. You cannot actually say that this particular water, this particular fluid, this particular liquid is made for that particular vessel. You cannot do that. But here in India, what we are doing is, after a strict scrutiny of that particular act, you will understand and you will analyze that the government has actually tried to, I would say, silence this particular development, silence or mute this particular development, because there is a section here in this particular act that said that any act or any step taken by the public officials, taken by the institution, taken by the government, furtherance of this particular act, that anything is mentioned in the act, and if the particular person does anything believing in good faith, that he is doing that in good faith, he cannot be held accountable. There cannot be any legal proceeding against that very person, that very government, that very legal institution. And to me, I suppose it's a very troublesome thing. Plus, there is this thing that was talked about in the judgments about self-perceived identity. In India, we have this concept that was given to the community to have a self-perceived identity. And to me, uh, in layman terms, self-perceived would mean that what a person believes himself or herself or themselves to be, they can be anything. It doesn't matter to who they want to personally be, what they want to align with. It's their personal choice. But in the very next section, there is a provision that said you have to make an application to the local district magistrate for application for a certificate of identity, and that is the biggest oxymoron there in that particular act. And I wouldn't take time because very recently in May 2020, guidelines were made. That is the transgender protection rules 2020. They were made, and there is another thing that if you don't want to go under SRS or sex reassignment surgery, you can have a self-perceived identity. Even then, you have to have an application from a psychiatrist. And to me, that is very troublesome because we started from somewhere. The judgment says something else, the act says something else, and the rules say something else. So we don't know in which direction we are heading towards. So we'll stop. I won't take much time, I guess.
Thank you so much, sir. I think when you were talking about popular morality, it also struck to me in my mind that collective consciousness is another word which is used in the present scenario. Thank you so much, Maureen and Najeed, for your very informative sessions. I would further like to move on to Angie for her part. You'll have to unmute yourself.
Sorry, I'm Angie Martell. I'm the founder of Iglesia Martell Law Firm. I practice, and I'm also the founder of Colobri Institute of Social Justice. And Colobri, in my ancestors' language, both Taino and Spanish, it means hummingbird. So what I want to talk a little bit about, so I practice in a lot of different areas: criminal, estate planning, family law, employment, a plethora of areas. So I've also been cooperative attorney for Lambda on some cases and the National Center for Lesbian Rights. Like Maureen, I come from it from a holistic perspective. I'm also a peacemaker and do peacemaking circles, but I've been a litigator for a period of time. So what I struggle with as an attorney, as an LGBTQ attorney, is the warrior and the peacemaker. And so I'll talk about that in a little bit. But what I want to talk about is what are some of the issues in the queer community in the United States. So the queer community in the United States is multifaceted. It's a very large umbrella that sometimes doesn't cover everybody. And when it rains and pours, most of us get wet. So, you know, there are white individuals that are part of our community, Latinx individuals, and under Latinx, it's very broad. Under Asian, it's very broad. Under African American and Black, it's very broad. There's also Native people, two-spirited people, transgender, gender non-binary, and a whole list of socioeconomic youth. So there's a very large umbrella, and we all have various, you know, issues that we feel are not always brought to the forefront by the LGBT legal community. The other issue for ethnic groups is that religion and our cultures and our coming out is very different than our white counterparts. And the demographics, if you look at the studies that have been done from the Williams Institute, it shows that 58% of the population that says that they're LGBT in the United States is 58%, but many people of color and ethnic groups don't disclose for fear of retaliation. Some of this is about I had a kid whose family, she was a Latino family, gave her an exorcism because she came out as transgender. Couldn't get the court systems to release her from her parents who were very hostile. She was 15 years old. She almost tried to commit suicide. It wasn't until she was 18 that we were able to get her away from her family, and this is in Michigan. The other issue is in estate planning, to be mindful of people who come to you and what their relationships are. So I started my career as a public defender in New York City representing criminal defendants. So what I'd like to do is think of it as a triage. When somebody comes to me, I look at what's going on with this person. What are all the collateral issues? What do they want? How do I empower them rather than disempower? because that's a very important thing. You're there to help. You're a counselor and not the rescuer. And also I noticed my own faults. For example, I have a queer Muslim case that I had, a parenting case out in Detroit. Very difficult for me because the person said I'm pansexual. And I was like, oh my goodness, how am I going to explain to the court what pansexual is? So it's about getting your own personal limitations as a lawyer and saying, okay, this is who my client is. I am going to educate the court on who this client is and not silence the client because you are yourself becoming the very barrier to a system that you say is limiting their own human dignity. The other piece is I navigate through very hostile terrain like Maureen, and sometimes not so hostile like, New York is not as hostile on some issues. So I look at, for me, the three key things as an attorney is portability. Is what I'm doing going to be able to be carried throughout the states so that they have the same legal rights if they move? Cultural competency. Am I really knowledgeable on this issue? On the queer Muslim case for parenting, I hired someone who was from the University of Michigan who was studying, her minor was Muslim religion, and she was actually from India. She was fantastic. And she was able to help me understand, how to argue or discuss this with the judge from a perspective of dignity. And that was very, very helpful. Sometimes our legal systems create categorizations and have an inability to be able to understand the individual because they have come with a one-size-fits-all. And I believe that the marriage case in the United States, although I really appreciated Maureen's work and everything, limited our community to a great extent because marriage is not the end all. For some people, we believe that marriage is a patriarchy, and although we like the 1,200 benefits that come with marriage, that sometimes it's limited because it excludes all those others that may not want to marry, cannot marry, like our seniors don't marry because they lose benefits if you get married. So educating the court system is one of the challenges we have as a queer community. LGBTQ youth face very different issues than many of us who are over 30 years old. For them, the larger social justice piece is much more important than the individual rights. So we have a difference between individual rights, which we've been arguing for the last 35 years, or a larger social justice that includes broader concepts and broader issues than just LGBTQ, and it's about building those bridges. Healthcare, the environment, or other issues. Our seniors have much more different issues than our younger people. Discrimination in services. I have had 3 cases that are horrible. 2 men that have been together for 30 years in the state of Michigan, never married for their own personal reasons. One of them dies. The other person was not listed on the house, and their family came in and said, I'm sorry, but you're a renter, you need to leave. Everything in the house belongs to Joe. There's the door. We'll give you a week. He can't bury that person because he's not legally related by blood or marriage. On the marriage cases, what I'm seeing a plethora of is I'm having to tell married people that they have to adopt the children that was born of the marriage because they are not legally related to the child. The birth certificate does not give a legal recognition. So they have to do a step parent adoption, which I've had to do for my own 17-year-olds, which is offensive because you are the parent. And then it's also discriminatory because it's based on a binary heterosexual model that doesn't include us. So those are some of the challenges. The other thing is on gender fluidity, which you touched on. That is an area that we need to do a lot more work on. I actually learned from India, because we're talking about learning from each other, that you guys have an X marker. And so I got that because somebody handed me their passport. They wanted to do a name change here. And I said, oh, X, what does that mean? And so she educated me, or they educated me about what that meant. And then New York, Oregon, and a number of states have now had the X marker. The challenges are going to be, you know, if they get a passport, will the passport give them an X? Will they go back to the gender markers of M and F? And then the whole plethora of things, Najeed, that you said, which is, are you going to require the surgeries or not require the surgeries? Are you going to go by what the person said, or are you going to have medical intervention, or how do we deal with that? The other thing I want to talk about is alternatives to litigation. So I do peacekeeping circles. So a lot of the issues, when I know that the judges are going to be hostile, that I'm in a hostile environment, I don't want to create bad law. I don't. So I try to find little building bridges so that I can say, okay, let's do a conscious contract. Kim Wright has a whole course on conscious contracts about how do we work together to create a contract for parenting time? How do we work together to create a contract for a polyamorous relationship where there are 3 or more people? How do we deal with your disputes? And as a Latino person, you know, we work within our community to try to resolve disputes rather than the legal system, because it hasn't always been to our advantage. So it's about thinking outside the box and finding solutions outside the box. The other thing is, so what are the challenges and obstacles we face? Definitely cultural competency. I don't think many of us are aware. Many of our colleagues aren't aware. I like the concept, and I think we started talking about this in the beginning with Farhan, about in Zimbabwe, they have what's called a grandmother's bench. And in the United States, we don't have enough people that can afford lawyers. So we need a support system that helps people navigate through some of the legal challenges they face. And I think that some of it could be law students, some of it can be people that are trained with skills like social workers and things of that sort, to give people the building blocks that they need to navigate through some of the challenges and disputes they have. Peace circles. So I think that those are kinds of things that we can do to break down the barriers of this traditional legal model that keeps the power consent, involved. One of the biggest things I think is important in LGBT issues, as well as other, civil rights issues, is to bring out the inconsistency. So a lot of what I do as a lawyer is to bring out, create the chaos in the system, to point out the fact that you say that you have equality, due process, fairness, but in this case, and in the matter in which you've marginalized people, there is no equality, fairness, and justice. So bringing out that inherent contradiction within a system that is really a system of oppression and marginalization is really important, because as lawyers, what we do is try to disintegrate that system so we can create the system that we believe is just and fair. Let me see. So what are the challenges ahead? I think in the United States, we just had a meeting this summer about the fact that the LGBT movement is not inclusive, not diverse, and not understanding of the plethora of people before it. And I think it was a very good conversation, because people then started to say, oh, I think I need to think about this more. Those of us that were people of color said, we can't help you with that. You have to internally, do that yourself, because it sort of came out in the Black Lives Matter that, we can't constantly be educating our counterparts, that they have to really take it upon themselves to figure out why haven't they really figured out that this is a problem until now. It's also about realizing that we are in a crossroads in America. We're in a civil war. I don't know what's going to happen this week. Is it this week or next week? Next week with the election. So that may, Maureen and I may be extremely busy and not happy about some of the things, or we're going to be extremely happy and working toward change. But I think legislation is really important. We still have, even though Maureen was successful in getting the marriage case, we still don't have the statutes that say, it still says male and female on many of the hostile states. We need to hold the line if things go bad and make sure that, that's where the warrior comes in. We hold the line and we hold up the sword to make sure that we help and empower people. But we are the peacemakers, like Gandhi said, and we want to cause no harm. But sometimes that's a really hard balance, and I have to be careful myself with the triggers. So I do believe that where we are the peacemaker is where we find the voice and light to help others, to build bridges. And, I think the moral fabric disturbs me because for me, the moral fabric is such a loaded, charged term that has come from a group of people in dominant culture that is oppressing marginalized people. They use the moral fabric to commit bad acts, in my opinion. So published opinions, you talked about that you look to the United States and published opinions. A lot of the great opinions are unpublished because judges are afraid of publishing what they say. So in one case, I asked the judge to change my client, who was 15, their gender marker and their name. And the judge says to me, well, I don't see that in the statute. What gives me the authority to do that, counselor? And I said, but judge, if it's not in the statute, what that means that you don't not have the authority to do that. So he granted it, but it wasn't published because he didn't want to stick his neck out for that purpose. And I really didn't care. So I want to thank you all, the organizers and all of you, all the panelists here today. And as my Buddhist wife always says, may we see the light in each other. May we practice loving kindness and do no harm. But as my grandmother, who is Latina, 4'7" woman, said, be strong, be brave, be true, and be who you always are. Thank you.
I think those were very inspiring words to end this session with all the speakers. I would request Maureen to add on a few words with respect to ANG's statements.
Thank you so much. Such a wonderful panel. I'm just so honored to be here. I do want to speak to a couple points. One, to Angie's point about the ongoing challenges if you are a person of color, if you are disabled, if you have other aspects and of other communities than one particular community under the laws, because unfortunately the anti-discrimination laws tend to divide as a way of winning. So the other side, that is in cases of employment discrimination, for instance, it's much easier for an employer to win a case if you can divide the characteristics of the individual who's bringing the claim. So if someone is bringing a claim, they're LGBT and disabled, LGBT of color and disabled, the courts try to separate the person, the parts of this human, and say, well, is it because you're disabled? Is it because you're a woman? Is it because you're of your sexual orientation? Which is it? And in doing so, it makes it harder for plaintiffs, for individuals who are challenging the laws, who are trying to get the protections to do so. And so there's a lot of education going on and a push started many years ago in the 70s by Professor Crenshaw, but on something called intersectional discrimination, trying to get the courts not to separate and divide out these issues and people. So that's one thing. The other thing, implicit bias training. So the legal system, lawyers, we all have implicit bias. And in Tennessee, there has been a push to get mandatory training for lawyers as part of our annual educational requirements, for all lawyers to get implicit bias training so that we recognize our own limitations and not impose norms on others that we should not be doing, and become more aware of the ways in which our language or our behavior negatively impacts others. So that's, I think, really important for that to be done. So I really appreciate Angie's comments on that. And I agree with Angie. It's really distressing when I hear the words moral fabric or popular morality, because from my perspective, that language is designed to maintain the oppression of others. So whenever someone uses wraps the status quo in language, let's use language and let's wrap morality and religion and into a concept that maintains the status quo, that automatically means that individuals who are being marginalized, who are already suffering, have a harder burden of acquiring equal rights. So I agree with Angie. It's a very troubling sort of language. And as attorneys, one of the ways that we try to change language as a practitioner in trying to change language is to use language in our discussions with other lawyers on the other side that furthers this conversation. So I always am bringing up implicit bias concepts in my dialogue with other lawyers, to bring issues of, we were talking as a panel earlier before we went on air about the use of pronouns, to talk with other lawyers about pronouns in whenever the opportunity presents itself, to open the dialogue with other lawyers at all opportunities that allow for a discussion to broaden the concepts, and then to bring that into litigation. So when I draft a complaint, one of the things I like to do, and I always think about, is, as Angie was saying, give voice to the client. The complaint isn't the lawyer's voice. It is the lawyer's guide. It is the lawyer's information about how the legal system works, but it is the voice of the client. And to always remember that I'm here because I'm supposed to help provide a voice for the client, and put that into the document itself. I put the law into the complaint to try and help the court understand the complexity of the problem, and not wait for an argument, but go ahead and at all opportunities put it in writing to the court of what the changes that our client is seeking, or what we're seeking on behalf of our client, and try to give that a stronger start point.
Thank you so. Surely.
One other thing, so I'm very fond of using outside forces to help my case. So when I represented trespassers from the University of Michigan on climate change, I used the press. I used communities to support. So look at where your allies may be, that not necessarily within the legal system, because your allies sometimes can make a bigger difference than your legal briefs.
And to Angie's point, as peacemakers, I'm a holistic lawyer. And what does that mean? That's essentially what Angie is saying. Lawyers as peacemakers. I started an organization in the early to mid 2000s on lawyers as peacemakers in Memphis, with the idea of sort of creating a dialogue around the idea that even if you litigate, as you problem solve every day, that your approach to other individuals, your approach to lawyers, your approach to your client, your approach to your legal community, your approach to other litigants can be in a peaceful way. You can use strong language. That's not to say that you can't tell somebody to get off your foot when they're hurting you, right? Get off my foot. And it doesn't mean you can't give them a little nudge. Apparently you didn't hear me. You're stepping and hurting my foot. But it is about respecting the others, all individuals involved in the process as people, as being in the process of learning, and to interact in a manner that aligns with my values of treating others with respect, even if I don't agree with them, and not engaging in creating harm to others by insulting individuals or yelling at individuals or misbehaving toward individuals just because they behave that way to me. And that I can still get my point across. I can still be a good advocate. I can still be a strong advocate, a brave advocate, like Angie was saying, her grandmother, whom I already like. It's just one of my great grandmothers was like 4'11", so I understand like this. You can be small, but you can be strong, and you can move forward. And I think that's a really important. What Angie said is a really important concept to embody in you in terms of how your personality can be in the world and how you can make a difference in the world in a manner that advances yourself and your community.
Actually, I would like to add something. As you all said about education, I personally feel that on the like talking about this topic here in India, there is a extreme lack of education. And when you said there that Angie said that when you have to educate the judge, you have to actually put forward the things in front of him so that he can actually understand. Because this whole concept, this whole situation is still under development. Speaking about India, it's still under development. The judge, he hesitates while giving this particular judgment or while delivering a judgment. They tend to, here in India, we have, when I talk about looking to the West, that concept, here in India, we try to develop a rationale based on things that have actually been tried and tested. We don't actually, let's say, we don't experiment with stuff. We are so inclined toward that already established structure of gender, or in that sense, any structure for that matter. So we are so inclined toward that actually existing structure that we are so afraid of actually tackling that particular thing, and we try to go about it. We don't actually try to educate it, because the reason I took this subject as my research, and the reason that I have interest in this particular subject, is because while discussing this particular, when the judgment came in 2018, while discussing this particular, I had very little knowledge. I'll be frank, I'm still learning, and I learned a lot today. But the thing is, when I was discussing this particular thing with my recently graduated, when we graduated from 12th, we were having this conversation with my colleagues that there is this issue that is coming into light in India. So what do you actually feel about this particular thing? What do you actually know? Like, I want to actually know what you what understanding do you have for this particular committee, the word transgender? What do you actually know about this? So the answer shocked me, because even a simple Google, even if you simply Google, you can have a better understanding of that particular subject. The answer they gave me was really shocking, and it was so ignorant. That particular answer was so ignorant, and they said that this is the thing that they actually don't why should they actually discuss it, because they are not getting affected by it. And when you say that we have this this popular morality concept, we don't actually have to bother about that section of the society. We don't actually have to bother. That is this perception that we have to tackle. When a judge of the Supreme Court, I'll repeat it, when a judge of the Supreme Court states in his judgment that we actually have to popularize this judgment, it is a message for the majority. And they said that even so, if this particular judgment is for this particular community, we have to have this judgment for the majority as well. They should read this. But when they say this, they are actually saying that we have to read a 495-page judgment. And to me, that actually is something that shocked me, because when I read that particular judgment of 2018, it was 495 pages. And in my conclusion, in my dissertation, I came across this suggestion that we should adopt simple language, because the community who is actually tackling this, let's say they're actually facing discrimination, they don't actually have the time or the means, because they'll actually go to the lawyers, and the lawyers are not educated in that sense. Because we cannot, here in India, we cannot expect a lawyer to be extremely educated when it comes to the trans community. We are all in a learning phase here in India. So for a person who belongs to the community, to him or her or them, as I would say, the judgment should be simple. That particular thing should be so crisp, as I guess in the US they have the simple or the plain language movement or the simple language movement. That particular thing here in India, what we do is we try to create literature. We quote from various jurisdictions. We use poetries. We have even used this opening sentence from Shakespeare, that what's in the name, and where Shakespeare say what's in the name, and it's so beautiful to read. But on the other hand, it's very confusing. It's really confusing. You have to have a legal mind. You have to have a very critical understanding of each and every concept of the Constitution and everything to actually decipher what actually is of essence, and that takes up all the time. So we don't have to actually create literature, and that is because I stated that we have indigenous literature here in India. We have indigenous say religious texts. We have everything here in India, but what we do is we overlook that, and we tend to just copy. And when you copy, you make mistakes. That's what I think. Yes, ma'am.
So Najeed, not to complicate your life, but I'm going to complicate your life. So the harbinger of things to come is the clash between science and law. So in artificial reproductive technology on family building, we're seeing more and more cases where artificial reproductive technology is being used to family build in LGBT and other couples, but in LGBT couples, since this is an LGBT program. So I think we're going to see in the future the issue, and Latin America is already doing this. I belong to the family law lawyers, LGBT in Latin America, and we're already seeing the clash between science and law on family building, and they've had some successes in Argentina on this issue. So I think it's the things to come in the future that we'll have to wrap our heads around, but definitely see surrogacy is changing in some of the roughest states like Michigan and New York. But I think that as LGBT people create their families and do family building, that's going to be a bigger issue.
I guess that's what we have to do here in India also. We have a very academic approach towards this topic. We tend to create, as I already stated, we tend to create literature. What I have actually done is I have an academic approach. I have done research. I have made myself familiar with the concepts, but we actually have to take it a step forward. Otherwise, it's just the government versus we are just voiceless. We have to actually educate. We have to. Hello. Am I audible?
Yes.
Okay. We actually have to educate the community as well as everyone here in India. So as to tackle these petty issues, which I don't think they should exist in the first place, but they do. I am having a little internet connection, so I'll just. You can get it, Farhan.
I think you talked about simplification of the judgments, which I totally agree with, because no layman will be able to go about reading 495 pages. It's essential that we simplify our judgments in order that it can reach out to the masses. Thank you so much to all the speakers. I think it was very intriguing for the audience. I have a few questions coming in from this very enlightening session. The first question coming in from Earth. What do you think is the way ahead for the community in India?
Can you just state who you are directing this question to?
I think this question can be particularly mentioned to Najeed because it's specified to India.
Okay. So the question is, what do you think is the way ahead for the community in here in India? Particularly, I would say that there has been quite a lot of activism that is going on here in India. As I cannot emphasize enough how important education here in India is, because when we tackle giants like religion, other institutions, other social institutions, and these concepts of, as I stated, concepts of popular morality, we actually have to pay a lot of emphasis on education. when we have a all-inclusive education from the very beginning. You cannot do something like, you cannot actually expect a person to pass his 12th from science stream and then say that you have to actually appear for a commerce exam. You cannot do that. You have to actually incorporate small bits. You have to incorporate things that actually have a everlasting impact on that particular. And education, as we all know, begins at home. We actually have to. And there's one thing that I would like to add is, we actually have to ask questions to ourselves. While while doing research on this particular topic, I asked questions like, if I go out if I go out to shop, for something, how many transgender shopkeepers do I see? Or do I have transgender colleagues? Or does my parents' colleagues have transgender colleagues? Or how, like, is it normal? You have to normalize it. You actually have to normalize it. You cannot actually expect people to normalize it. The only way out is education. To me personally, it's education.
We have the next question coming in from Arvind Upadhyay. What are the challenges of LGBTQ families with reference to child adoption? I would particularly like to mention this question to Maureen because of her expertise in these cases.
I will answer in part, and then I'm going to defer, of course, to Angie, since she does a lot more family law. But the first thing is that the Obergefell case consisted of a number of parents who one of them had adopted a child, or they adopted children. And did you catch that? I saw a glitch in the monitor, but there were a number of plaintiffs who had adoption concerns where one parent had adopted, and there were single parent adoptions. And what would happen if if that person passed away or something happened to them and the other parent needed to take over the full parenting responsibilities? Would the law allow that? And in some states, the answer was not, unless you're married. So this was not specifically addressed by the Supreme Court in the Obergefell case, but it was addressed by the Supreme Court in 2017 in a case out of Arkansas called Parvan versus, I am blanking on the last name, but it was Parvan case out of Arkansas. And in that case, the Supreme Court references Obergefell case. It is Smith, Parvan versus Smith, out of Arkansas. And the Supreme Court references the Obergefell case and overturns Arkansas Supreme Court because Arkansas Supreme Court said, no, we're not going to list both parents as parents on birth certificates or other documentation. And the Supreme Court in Parvan said, no, you have to do that. A marriage, in order to have equal benefits, basically, it was a per curiam, so they didn't go into much detail. They're just like, see Obergefell, you should do right, fix this. And so I think but I think, to Angie's point, is still a concern, because although one case moves up through the system in Arkansas, that doesn't mean that other states feel comfortable. And there's a constant challenge in the United States, in every state, with organizations and legislation designed to stop families from being families and stop LGBTQ families from being families. And so there's this constant warfare that Angie mentioned. And so to protect themselves, many individuals do and probably should create other documents. I don't think that's what we want, but that's what the reality is. And I'm going to pass to Angie.
So this is a complicated question because it's very fact specific and geographical specific. So fact specific, the reason is, if the child was born of a marriage, a same-sex marriage, it's presumed to be a child of the marriage. If the genetic material belongs to wife one and she gave it to wife two, wife one would never be considered a parent, even though the genetic material that created the child is that is hers. However, if a known donor gave sperm, which takes a nanosecond, that person would be a bio parent in Michigan. So again, it's very fact specific towards the geographical location. In New York, if you contributed in a sperm bank, even if it was known, that person would still have no rights. So again, you have to ask a lot more questions about it. Some of the issues is about portability. You know, if you create a document in Tennessee or Michigan, is it going to have legitimacy in another state? That's something we need to think about. The thing that's ironclad pretty much is adoption. Why would you want to do an adoption if you have a birth certificate, the child was of the marriage, you bought the sperm? Because the problem is when you get to estate planning and Social Security benefits, the problem is the statute says blood or legal relation. Now, a birth certificate is not a legal relation. A marriage is not a legal relationship because it's a presumption. If somebody comes forward and say, hey, gee, I had sex with wife 2 and that baby's mine, and they do a paternity, and yeah, he was the known donor, you've got a problem. So again, you want to, have a complete conversation with your client. National Center for Lesbian Rights and Lambda Legal Defense is now recommending that people who are in same-sex marriages do the second parent adoption, do the other piece. Because in my case, for example, I'll give you a personal story. My kids are twins. 17 years ago, they were born. We were not able to get married. So we had children that we could not I could not have a legal relationship with. And so when they were 8, we were able to get married in the state of Connecticut. And I had that piece of paper that says I'm the adoptive parent. Doesn't feel so great, but when we moved to Michigan and my marriage wasn't recognized, I was the legal parent of this child. If I die, these children get my Social Security. If I didn't have the adoption, they can't get my Social Security. They can't get a plethora of other benefits that all children should get. So those are the challenges for LGBTQ families in reference to the child adoption. And if the person was married before and there's a bio father, very uphill battle.
Thank you so much to both Maureen and Angie for these wonderful opinions on this question. I would like to take the last question of this very special evening. In the US, I think the media, that is the TV shows, celebrities, etc., contributed to the acceptance of LGBT marriage. Are there prominent celebrities that can start to unravel that majority moral fabric?
So while I agree with the writer that, whenever you have people like Ellen DeGeneres that come forward and celebrities that support marriage and support LGBT and support transgender issues, support non-binary, it's also helpful. But at the same time, we have to be mindful because people like Caitlyn Jenner, who had the money to do all the various things she did, many transgender people, especially transgender people of color, do not. And it establishes a barrier because it's assumed, oh, this is the standard. And that's a standard is so far beyond all of us that it's an impossible standard to reach. And again, we're talking about normalcy. People want this, well, how's it look? What's it going to look like? And we're all so different and diverse that it creates a barrier for all of us. And, I think we got to be careful on that little one.
If anyone wants to add on to that answer.
This is Maureen. I agree with Angie that you have to be very careful whenever you are speaking on, essentially suggesting that you're speaking on behalf of a full community when your voice is a portion of that community. And I think that's always something to be mindful of. I do think, of course, it helps to have individuals others who are less educated, to Najeed's point, who don't have the opportunity maybe to have access to information, no fault of their own, but to when they see someone who is a celebrity, who comes out and says positive things about the LGBTQ community, that helps. It is not the end, as Angie mentions. It's a portion, and it's something to always be mindful of, to do it in a manner that is respectful to all of the voices of our very diverse community.
If I can add a last point, I think it's helpful to also people see, like, you know, in the beginning, in the 60s, we saw people of color in TV programs. So when we start to see people that are like us in regular programming, that helps a lot.
I think I would like to ask Kim ma'am to make a few concluding remarks for the whole session.
Just really briefly, I want to thank everybody for the conversation and for participating, for accepting the invitation and being willing to, in the case of Angie and Maureen, get up early in the morning and, you know, and show up. And Najeed, it's nice to meet you. And I hope we see you again in future programs. This has been really great. I'm looking forward to sharing it on social media and spreading the word. And this is a series. So next month, we're actually going to be doing something completely different. We're going to be talking about visual contracts and using art in contracts. So I hope everyone will join us for that, and that you'll join us for the rest of the series. Thank you, Farhan. And we have a new editor, I think, that I haven't met yet, who's just also joining us. Maybe she'll take just a moment to introduce herself, and we'll be finished for the day.
I would like to call upon Ms. Groleen Kaur for giving the formal vote of thanks for this session.
Okay.
Hello, everyone. Thank you so much for this wonderful session. We have really enjoyed this. And on behalf of the entire team of Law Essentials, I would like to thank all the speakers for taking out their precious time for conducting this third episode of Lawyers and Peacemakers. Especially, I would like to extend my thank you to Ms. J. Kim Wright, ma'am, for the guidance and providing a platform to introduce professional speakers here in India. We are extremely overwhelmed by the participation in the webinar. Thank you so much for joining us today. Looking forward to have more sessions like this. Thank you all.
Thank you.
Thank you so much for all of you for joining us today evening. It has been a pleasure to host this event. Signing off today this evening is Mohammed Hansi. Thank you so much.